A forensic report can make or break a case. But what if the science is shaky, the procedure is flawed, or the expert is unqualified? In this video, let's dissect how you can legally challenge the admissibility of forensic evidence in court and turn the tide of a criminal trial in your favor. Hello and warm greetings to everyone. This is Dr. Arjun Chowdhury, advocate. Today, we are going to discuss a topic that plays a decisive role in many high-profile criminal trials, that is, how to legally challenge the admissibility of forensic reports in courts. Let's begin by understanding one legal principle. Forensic reports are not sacrosanct. They are admissible only if they pass legal and procedural tests under the Indian Evidence Act, Code of Criminal Procedure, and the relevant forensic protocols. Under Section 45 of the Indian Evidence Act, the opinion of a forensic expert is considered relevant, but relevant does not mean admissible. The Honorable Supreme Court in State of Himachal Pradesh versus Jailal clearly held that expert opinion is merely advisory and the courts are not bound to accept it blindly. You must test three pillars: expert qualification, proper procedure, chain of custody. Now let's go through 5 strong legal grounds on which forensic reports can be challenged. Question the expert's competency. Cross-examine the expert on their academic background, number of years in their service, practical experience in the specific test performed. If their competence is questionable, the report stands weakened. Chain of custody break. If the sample was not sealed properly or was not traced securely from collection to lab, raise objections under Section 165 CrPC and demand proof of continuous custody. Without chain of custody, tampering cannot be ruled out. Lack of accreditation or protocol violation. Was the test conducted in an NABL accredited lab? Did they follow standard protocols prescribed under the Directorate of Forensic Science Services guidelines? Any deviation renders the report unreliable. Contradiction with ocular or other evidence. Forensic findings must be corroborative and not contradictory. For example, if the blood group or DNA does not match the accused, the prosecution must explain the discrepancy. Absence of raw data or test benchmarks. Demand the raw test results and comparison benchmarks. Often, labs only provide conclusive opinions without analytical backing. In such cases, file an application under Section 91 CrPC, which is Section 94 of the new law, that is BNSS, to summon full test records. You can cite cases like Selvi versus State of Karnataka. Supreme Court held that involuntary forensic tests like narco analysis violate Article 20, Subarticle 3. Manu Sharma versus State of Delhi. Court held that the faulty FSL reports with procedural lapses cannot be the sole basis for conviction. And a very recent landmark judgment of the Supreme Court in the case of Rahul versus State of Delhi, where Supreme Court held that forensic reports cannot be the sole basis of conviction, particularly when there exists procedural flaws in collection and handling of samples. So what are the strategic tips? File an early objection under Section 293 CrPC if the report is filed without calling the expert. Ask for a second opinion from an independent lab. Request the court to issue a direction under Section 311 CrPC to summon the expert for cross-examination. Remember, in law, a flawed procedure equals a flawed result. Just because a report is technical or scientific doesn't mean it is gospel. Challenge it with the same rigor as any other evidence. If you are an accused, counsel, or academic, knowing these grounds can help you defend truth and justice in a courtroom increasingly influenced by science. That's all for now. This is Dr. Arjun Chowdhury, advocate. See you in the next episode, and until then, stay legally empowered.